Now we're talking about loyalty. I want to thank the audience that have been so loyal so far, because we are now after 6 o'clock. So I will try to do my best to be very short. And as you see, I had a PowerPoint, but I won't use it, because then you will see how many slides I won't be able to deal with, which is not the right thing. I am asked to talk, or I gave myself the topic, authorizing the UK to negotiate transatlantic trade agreements before Brexit. Now, this is very much an article or a chapter which I'm still in the process of writing, and I will try to cut out most of the things which are crystal ball gazing. But I want to start by explaining to you how I got to this topic. That was because when I was asked to give a presentation today, I just have read an article by Thomas Strines on cooperative Brexit, in which he talks about and argues that it is possible to authorize the UK to negotiate alongside the EU trade agreements before Brexit. So I said to myself, well, that's brilliant. Since he has argued that it is possible, I will investigate the question as to how to do that, how that should actually go into work, and this amounts for the number of slides, which I'm not going to show you. And I said, in actual fact, it's easy because there are 3 regulations already which deal with empowering member states to negotiate in a field of exclusive member state competence. And I'm just going to take the best parts of that and then say, well, you see, this is how to do it. And just for you to know, the 3 regulations are Regulation 664, 2009 by the Council concerning jurisdiction, recognition and enforcement of judgments and decisions in matrimonial matters. Very interesting, because it is a question of closer cooperation. Not all member states are involved. And then the second one is Regulation 662, 2009 of the European Parliament and the Council concerning the law applicable to contractual and non-contractual obligations. And then the third one is Regulation 1219, 2012 of European Parliament and the Council on bilateral investment treaties. So, but then I said, well, maybe I should, beyond what Thomas Strines has said, also reflect on the question why or why not to empower the UK to do this. And there are a number of political but also legal considerations which you have to take into account before even considering all these more detailed questions. And then I said, well, after we have discussed that, then maybe we should look into questions such as the procedure for empowering the UK, and then look at the content of the Act, and then present my conclusion, which is that such empowerment is legally possible, but can it be rushed through? Because that's another consideration. So let me consider first the question of why would you not empower the UK to negotiate a trade agreement alongside the European Union? There's a number of political aspects to this, and I will rank them in a specific order, and then I will deal with the legal considerations which have to do with the question of exclusivity and also the constitutional debate. So, but let's go to the political questions. One of the political reasons for doing so may, of course, be because the United Kingdom asks for it. So the question, has the United Kingdom asked for it? Well, there is rumors that the UK would like to do so, but no definite document has reached me yet that such a request has been tabled. But it might come if you look the general words that come from Westminster. So that might be one reason. Another reason, very important, may be because if Brexit materializes, we don't know if it's the case, but if Brexit materializes, then that may lead to the impossibility for the European Union to honor certain of its commitments. So there may actually be an interest of the European Union to be up to that proposal. The third reason is the need to avoid disruptions in international trade, combined with the reason of the length of negotiations and the time frame which is imposed by Article 50, which, as you know, is relatively short if it's not extended, and it's preferable that it is not extended. So, but then there is a lot of political arguments also against it, and the European Commission negotiator, Michel Barnier, takes the viewpoint and brings it very clearly that the United Kingdom must, first of all, honor its obligations, and you have these three priorities in the negotiations, which before negotiations can even start. Apart from that, there is also the question of the manpower involved, because the United Kingdom is not very much used to negotiating trade agreements, if not from inside the European community, let alone do it outside when it is a much less powerful actor. I'm sorry to put it that way, but that's how I feel about it. So, but then there's also of course, the length of the procedure for the empowerment itself, because decision-making, co-decision in the European Union can take a long time. There are certain statistics about this, which says that if it is a co-decision, then it would last 2 months and up, because co-decision takes 2 months and up, and the average period of decision-making in co-decision, the average one, is between 17 and 19 months, as you can find out on the internet. So this would bring us up to spring 2019, and thus at the end of the normal Brexit procedures. But maybe there's another way around it, and that is, and then you come into the legal debate. Is it possible legally to empower the UK to negotiate trade agreements? And of course, the first notion that comes to mind is the notion of exclusivity, but as we all know from Article 3 to an Article 3, the common commercial policy is an exclusive policy, but that doesn't mean that the member states cannot do anything. They still remain responsible for the implementation of the Common Commercial Policy Act, and they can be empowered in any field of exclusivity if the Council so decides. Then there comes in the constitutional dimension. I tried this argument out in a discussion on transatlantic relationship in the context of an international summer school. And so I said, why don't I not ask that question so that maybe the audience can give me their view? And there obviously was a gentleman from London School of Economics. It was not the one who was sitting next to me.
Got nothing to do with this. Huh?
Yeah. And he said, you know, this is not at all common commercial policy. Because common commercial policy is an agreement between the European Union and a third state. And this is not an agreement which would benefit the UK. And so I said, well, wait a minute, so it's not that easy. So one could actually argue that Article 50 of the Treaty on the European Union, the Brexit procedure, is a special case. It's a constitutional agreement which needs implementation. Now, if you look at Article 50, you will not find anything about empowering a member state. But if it doesn't say anything, you have always two possible positions. One position will say that if it is not in there, it is forbidden, and the other one will say if it is not in there, it is allowed. But what is sure that if and in that case, it is the European Council and not the Council of Ministers who decides with the Parliament, and it is the 27 who have to approve it, and not the 28, including the UK. So that would provide a faster procedure, and by that procedure, you could say that the 27 would actually, I wouldn't say amend the Treaty on the European Union, but they would effectively create a precedent with constitutional implications. So that's the thing to watch, and that's why I'm so great to the organizers that I could consider these questions, because they're all new questions and they fit entirely into the what's happening today with lots of insecurity and uncertainty. So what I was meant to deal with, the content of the Act by comparison to the three examples. Well, here I want to cover the objective which are addressed in the Act, the scope of the Act, very quickly about this. It is about empowering a member state to negotiate in order to amend an existing act. Let's say CETA, or let's say more agreements, but let's just look at CETA because it might be politically interesting to do so, and of interest also to the European Union, because by the empowerment it can at the same time set rules and give more meaning and more concreteness to the principle of loyalty, which my colleague here has addressed beforehand. So the scope then addresses questions of should the empowerment just be for matters that come within the exclusive powers of the European Union, or should it be also contain rules relating to matters of shared competence and maybe even matters of member state competence in the context of a mixed agreement? So that's, these are very interesting questions. I have to be short. The regulations concerned also contain provisions on transparency of negotiations, transparency of information, and with that also confidentiality of negotiations. So the three regulations here, they contain different obligations, especially for the member state who is being authorized, but also the relationship is both ways, because the member states have to share information about the holding, the start of the negotiations. They have to pass on documents, and then there's provisions about whether the Commission can share these documents with the other member states, etc. And there is Regulation 1219 2012 on bids, makes an exception for confidential information. And then you can mention another regulation, Regulation 1049/2001, regarding public access to information, which could then be used to implement this, let's say, acquis, which already exists. Yeah, and then for these regulations provide for a duty to notify every single meeting that is taking place, the agendas and all pertinent information, and then possibly the regulation or the decision by the by the European Council can provide for implication of the European Union in the process, either as an observer or as a co-negotiator, and the latter then provides for the maximum of transparency. Then there is also a duty of cooperation. There's no surprise there. Duty of cooperation provides for a duty, as I said, to notify the start of the negotiations, but also on the Commission side, the Commission has a duty to take within a number of days, let's say 90 days from the request, to take a decision on the admissibility of the negotiations, and there are criteria for which the European Commission can refuse the negotiations to take place, notably when they are illegal, when they're not in conformity with the treaties, or when they sort of make it impossible for the European Union to negotiate. The Commission, in some of these regulations, can also ask the Member State to take a position on a particular issue, and there can be a negotiating framework, as is sometimes done in the case of mixed agreement. And then finally, there are provisions on judicial oversight. The Commission, when this comes specifically from the BITS regulation, which can be used as an example, the Commission, when authorizing the UK, should assess whether the agreement is conform EU law, or whether there's an obstacle to the conclusion of the agreement. The Commission shall be kept informed. These are all in favor of its function of oversight. They must be kept informed of the progress and the results of the negotiations, and as I said, they may request to participate. There shall also be the authorization to sign the agreement has to be obtained from the Commission, and it is also possible to conceive of provisions which indicate what happens in the case of dispute settlement against the in the member state of it, or the European Commission. There's provision for a special committee. There is provision for a report to the European Parliament or to the European Social Committee. And then it should be provided that the jurisdiction of the European Court of Justice should apply at least until Brexit. Finally, there are procedures for expiry, because any of these issues must be remain temporarily in order not to have a permanent delegation, but in order also not to encourage other member states to ask for certain exceptions. So one can say that the regulation must expire at the date of the United Kingdom. The United Kingdom leaves the European Union, or at the date Brexit negotiations terminate, which will happen, whichever is the earlier. So in conclusion then, empowerment is legally possible. However, can it be rushed through? And there, what we have said on the co-decision procedure is particularly discouraging, but that raises the question of whether it can be done in the context of Article 50, and if so, in the context of what type of decision do you allow for this? Thank you very much. I hope it was not too long.